He is charged with prosecuting cases all over the world. So we'll hear about her mandate and some of the challenges that her court faces. Fatou.
Thank you. Thank you, Leila. I'm very happy to be here. First of all, I bring you greetings from the prosecutor, who unfortunately could not be here, but I'm benefiting from that. Don't tell him. And I'm glad to be with you today. As Leila has said, the International Criminal Court is the first permanent, independent international criminal court. And this year is particularly very interesting for the ICC because as we also celebrate the 60 years of the Genocide Convention, we are also celebrating 10 years of the adoption of the Rome Statute in 1998, when countries voluntarily submitted to establishing a permanent international criminal court. The ICC's jurisdiction is very similar to the jurisdiction of the other ad hoc tribunals. It is over war crimes, crimes against humanity, and for genocide. The only additional one is aggression, but that has to be defined first. A definition has to be found for aggression before the ICC can take, before it can be fully under the jurisdiction of the ICC as a crime that we can investigate and prosecute. There are some new aspects in the ICC which you do not find, for instance, in the ad hoc tribunals. And this is the issue of complementarity. And I'll explain in the sense that I mean. The ICC's jurisdiction is not primary. It is a court of last resort. And this means countries that normally have the mandate to investigate and prosecute crimes falling within the jurisdiction of the ICC, if they are doing this, if they are investigating and prosecuting these crimes, then ICC will take a back seat. ICC will only intervene if those investigations and prosecutions are taken to shield a person or are not being done genuinely. Then the ICC, the Office of the Prosecutor, has the right to go back to the chamber and draw attention to the fact that these prosecutions are being taken, but they are taken only to shield a person. Presently, about 104 countries are members of the International Criminal Court. They have signed and ratified the Rome Statute. We effectively started investigating and prosecuting, let's say in 2005, when we received a referral from the government of the Democratic Republic of Congo, later on closely followed by the government of Uganda, referring their cases to the ICC and inviting the prosecutor to go in and investigate and prosecute. Let me talk about briefly how the jurisdiction of the ICC can be triggered, because I think this always forms a very important basis for the discussions why ICC is not here, why ICC is not investigating a certain country and leaving out others. The ICC has jurisdiction over the territory of a state party. When crimes are being committed on the territory of a state party, the ICC has jurisdiction. When crimes are being committed by the national of a state party, the ICC has jurisdiction over that national of a state party, irrespective of where he's committing that crime. The ICC's jurisdiction can also be universal because the United Nations Security Council can refer a case to the ICC from anywhere in the world. And this is what has happened in the case of Darfur, Sudan. As we all know, Sudan is not a state party to the ICC, and this is the claim they continue to make. They are not a state party, but the United Nations Security Council, acting under Chapter 7 of its powers, has referred a case to investigate and prosecute the Darfur situation, the Sudanese situation. And this is why the ICC has been investigating, resulting in the warrants that have issued against Ali Kuchik Ahmed Haroun, and now we've made an application against the president of Sudan. Another aspect which I think I should also highlight, apart from complementarity, is victim participation. This has been referred to briefly by Robert, but I also want to say that also for the first time, for an independent, permanent international criminal court, victims can participate. The ICC statute provides for victims to be able to present their views and concerns, and also to ask for reparation. This is the first that is happening. And of course, all of these are on paper, are in the statute, but over the past couple of years, the ICC has had to translate this into reality. And of course, it has created tensions, and all what the ICC, various organs are trying to do is to make sure that the modalities and the scope of participation of those victims, are properly sorted out before even the court moves ahead. So for the past year or two, we have been making various submissions regarding the participation of victims and how we see it and how the court sees it. And we hope that we will be able to put a system in place where this will be properly. Victim can truly participate in a meaningful way and get something out of the proceedings as was intended in Rome in 1998. For the past, since we started investigations, we are now handling about 4 active case dockets. By reason of a referral from the Uganda government and from the Democratic Republic of Congo and from the Central African Republic, the ICC has opened investigations in all those situations. And with respect to Uganda, we have issued 5 arrest warrants. Unfortunately, 2 of those suspects or perpetrators have died, and the warrants that have not, the others that have not died, their warrants are still outstanding. It has not been executed. We continue to call on the international community to have the warrants executed against Joseph Kony and the 2 other commanders of the Lord's Resistance Army for the horrendous crimes that they have been perpetrating in the northern Uganda and also in other parts of Uganda for over 20 years now. This has been happening. Children are being kidnapped, children are being turned into killers, they're being turned into sex slaves, and this continues to happen. And the challenge the biggest challenge that we face there is that we have the paradigm of peace and justice. Some people are saying that give Uganda a chance to have peace, they can negotiate and come up with a solution to their problems. But what has actually happened is that Joseph Kony had never been serious about negotiating for peace. It was only after the ICC, or I can say that it formed a big part of it, it was after the ICC has issued warrants against Joseph Kony for his arrest that he is appearing to be serious about negotiating for peace. This has brought him to the negotiating table, but we have seen that process has broken down a couple of times, and in the meantime, Joseph Kony has used the opportunity and the monies that are being presented to him to rearm, to regroup, to extend his crimes. Now it is beyond the borders of Uganda. We know that he's committing these crimes in Central African Republic. We know he's committing the crimes in the Democratic Republic of Congo, and we know he's committing the crimes in Sudan. So this is now transcending national borders. It's going into regional neighboring countries, and children continue to be abducted. And these crimes continue to occur. Meanwhile, the so-called peace negotiators are always forgetting that accountability is also very important in the process. What we need to do is really look for ways to see how we can complement each other. Not to say, start sequencing, not to say that because we are negotiating for peace, justice should be pushed off the table. We continue to ask for this. A similar situation